give you guys another second for folks to come in and take a seat. All right. We've got some seats up here in the front for those of you in the back that are coming in. Welcome. They're right over here to my right, your left. We've got a couple of seats over here. Please come on in. This is a really great interactive session, and we'd love to have you be comfortable and settle in. The time just flies by, honestly. Okay. All right, and if at any point during our time here, if you guys cannot hear us, please raise your hand and we'll adjust where we're talking in front of the microphone. Good afternoon. Thank you. Welcome to the new Mayors and Council Members Academy. We want to congratulate all of you that are here, our new City Council members and new mayors as well. We know that you'll be enjoying your time on the City or Town Council, representing the interests and implementing the goals of your city. We wish you all great success. We thank you for joining us here at the Academy and in our session this afternoon, where we'll be reviewing your legal powers and obligations as you operate on the City Council. As you may not know, I'm Corinne Kelleher, the Assistant General Counsel at the League of California Cities. I work for Patrick Whitnell, who is our General Counsel. We are very fortunate today to have beside me Jane Williams. She is well known across the state for her distinguished experience as a city attorney. Jane's been practicing municipal law for her entire 40-year legal career. She began her legal career in the Oakland City Attorney's Office, where she held various increasingly responsible positions, including serving as the city attorney there from 1987 to the year 2000. After leaving the city in 2000, she joined the law firm of Myers-Nave, where she continued her municipal law practice, serving as city attorney, general counsel, and special counsel for many public entities, including Suisun City, the City of Merced, the City of Stockton, City of San Leandro, and finally the Mount Diablo Unified School District. Jane was a principal and partner at Myers-Nave and served as its managing principal for 6 years. She's the recipient of numerous statewide honors and awards. She also served distinguishedly as the president of the City Attorney's Department here at the League in the past few years. She continues to consult regularly with Myers-Nave on special projects and legal projects, in addition to pursuing other professional and personal interests. It's absolutely an honor to be here today alongside Jane. Thank you, Jane. I always look forward to this day because I get to have lunch with Jane and then present with her, and it's just a treat. You'll see. Our goal today is to present a basic overview of these legal issues. We'll be covering general principles related to the sources of city powers and limits on that authority, as well as some very important open government requirements that Jane will focus on in her presentation. We'll leave specific areas for you to learn about in other sessions here at the conference, including land use and planning later this afternoon, of course, finance and revenue in more detail than you'll hear today, tomorrow, and more particular ethics requirements in your AB 1234 training that will happen on Friday morning. As you know, we've got a paper in your materials along with the PowerPoint that you have with detailed background, more detailed than you'll hear from us today. We really encourage all of you as well to take advantage of the excellent resources available to you all as a member of the League when you get back to your city or town. We have a great website. I'm sure most of you are familiar with it already, but I really want to point you in particular to the City Attorney's Department pages that we're very proud of and continue to try to update and make work for you. There's an excellent Public Records Act guide and Brown Act Open Meetings Act guide, both available right there to download. If you don't know where they are, let us know. We'll show you right where they are with recent supplements, so they're absolutely up to date. They are written by expert city attorneys from across the state, many from your city or town, who spend their time literally writing these guides and providing supplements to provide the tools that we all need to properly do our jobs for our cities. Our city attorney's department is very fortunate to have so many of our city attorneys and assistants and deputies, again, many from your towns or cities, helping us with these projects. They help us on understanding pending legislation, understanding new statutes that actually get enacted, court decisions that come down constantly affecting cities, and they also help us write amicus, or what we call friend of the court briefs, that advocate for the interests of California cities before our appellate courts, both in the state court here in California and federal courts. One of my responsibilities in the legal department at the League is to staff the legal advocacy program. Again, many of these lawyers write on their own time, on their volunteer time, whether they're in-house attorneys or from the law firms that work with cities, appellate briefs and letters to the California Court of Appeal, to the California Supreme Court, the Federal Ninth Circuit, and also the U.S. Supreme Court. Attorneys from Jane's firm, Myers-Nave, have helped us for many years in the program. In fact, one of your colleagues, Jane, is writing as we speak an amicus brief for the California Supreme Court, and we're very grateful for that. There's about 20 cases currently pending right now on the California Supreme Court docket, all important issues facing cities. The League has weighed in on about 19 of those cases with these amicus briefs. Of note to you, and it might ring even truer to you in your next session, there are several cases now before the court on the California Environmental Quality Act. We have weighed in with amicus briefs in almost all of those cases. We're expecting decisions to begin being handed down in the coming months and year or year and a half. So it'll be a very interesting time during your service on the council as you see the CEQA law continue to evolve as these decisions start to come down from the California Supreme Court. We've also got two really interesting cases on the U.S. Supreme Court docket right now. One of them involves liability for cities or police under the Americans with Disabilities Act for police officers that encounter folks with a mental disability in answer to a call. The other case involves challenges to city ordinances that allow police inspection of hotel registries for public safety purposes. So again, we weighed in on both those cases as well. So it's a very interesting time to be involved in our amicus program. Last thing I'll say before we get started is, if you don't remember anything else from what we say to you today, your only task is to work with your city attorney when you go back to your city. And you'll, as you listen to us go through our stuff, you'll think, oh, now I know why they're saying we should work with our city attorney. This is really hard stuff, and it's confusing. Our guides are helpful. Your attorneys are ready to work with you. Your city manager's ready, and your finance director. So if nothing else, you know that you've got the help you need when you get back to your city or town. So with that, let's go to our agenda, and I'll quickly tell you what we're going to cover. Bear with me. We've got a different setup here than I'm used to, so I'm going to do my best, and I think I'll be okay. Yeah. Okay, so here's our agenda for the day. Jane and I will address you first. We'll then go into a very lengthy question and answer period, which the history has been that it's been very helpful and more interactive to kind of keep it going as the afternoon continues. I'll talk about the first three topics: city powers and limitations, general law cities versus charter cities, and basically an overview of raising revenue in your city. Jane will then take over and talk about open government and transparency issues. She'll be touching on some ethics issues, although again, we know you'll be talking at length about those issues on Friday. She'll also touch briefly on the city council members' role concerning city employees. So let's move right along here, and okay. Tools. We'll jump right into the sources of law that affect your role on the city council. Again, your city attorney is an expert at translating these sources of authority and power, as well as the constraints on that authority, so that you can get ensure the positive outcomes that you want to as you work on the city council. Primarily, your most important source of law is the California Constitution itself, where cities are granted broad home rule powers and authority to govern locally. The Constitution also defines the nonpartisan nature of city government and has some express limitations for city authority. For example, in areas such as water rights or workers' compensation, alcohol, beverage regulation, and the like. It's expressly set aside for the state. Changing the Constitution requires a vote of the people, as we know, and proposed changes can be placed on the ballot by the legislature or by individuals who gather enough signatures on initiative petitions that we constantly see in front of all of our grocery stores. The U.S. Constitution applies nationwide, of course, and imposes, usually imposes more limits on local government authority. City laws and actions must comply with the United States Constitution. For example, the protections ensured under the First Amendment for freedom of speech, Fourth Amendment prohibiting unreasonable searches and seizures, and Fifth or 14th Amendment requirements protections for due process, equal protection, and property rights for all Americans. California statutes, near and dear to our heart here in Sacramento. These are our state laws enacted and codified by the legislature. I'm trying to think, right across the street, I think that's right over there, providing both power and authority as well as constraints and limitations on general law cities, and those are the cities that don't have a local charter. The state also regulates in areas matters of statewide concern through statutes, and those statutes apply to all California cities, whether general law or charter cities. Voters, of course, can amend the state statutes through the initiative process as well. And I think, as you've already heard earlier today, our league legislative team works very hard all year advocating across the street for cities on proposed legislation and in proposing or trying to work with our members on legislative initiatives to help cities. The U.S. statutes, our federal statutes, are the nationwide laws enacted by our Congress in Washington, D.C. Often those laws provide more limits on our activities locally, on our authority, or require certain actions by cities. Examples include federal civil rights laws that prohibit discrimination by cities, environmental laws, another good example. For example, the Clean Water Act that imposes obligations on cities as they manage stormwater and other sources of water. And then disability laws, like the Americans with Disabilities Act, for example, again, at the U.S. Supreme Court right now. Those requirements apply to cities not only as employers, but impose accessibility requirements for our city public official facilities and services and other programs. Importantly, for everyone in the room here, the city ordinances are next. These are the local laws that result from your actions acting as a city council. They apply within your town limits. They're codified under your local municipal code. And of course, your local voters in your city can amend a city ordinance through the initiative process as well. For those of you from charter cities, where the citizens in your town have elected to have a charter, the charter document itself operates as your local constitution. It also provides that city with additional home rule authority to make local laws governing municipal affairs, even if there are state laws in the books that may conflict with those ordinances. Charters can also contain self-imposed limits on city authority as well. Finally, and near to my heart, court decisions and case law. These, of course, are the published appellate decisions in state and federal court that interpret all of these sources of law and apply them to the facts of a particular case, resolving a conflict or an ambiguity, resulting in binding legal precedent that can empower cities or limit cities' authority in the subject area. Getting back to our League Amicus program, our goal in filing these briefs and letters is to help and teach the court the potential impact or effect on the ruling in that case to all California cities across the state. So we have had great success with the program and feel strongly about its importance as the case law in our areas continue to change and evolve. So what are some of our powers and authority under the California Constitution and state statutes in cities? First and foremost, the power to tax city residents to raise revenue for public purposes. Of course, there are limits on the power to tax under the state constitution. We'll be talking about that in a minute, including constraints on the amount of property taxes that can be collected and requirements for voter approval before imposing or raising taxes. Cities are authorized as well to acquire real property for a public use, including by purchasing property through a negotiated agreement or by eminent domain. Eminent domain acquisitions are subject to an extensive process as laid out in state statute, any taking of property by eminent domain requires payment of just compensation to the property owner. As also stated expressly in our Constitution, cities have the power to establish and operate public works, to furnish their residents with light, water, power, heat, transportation, such as buildings, streets, sidewalks, city bus systems, communications, including maybe a cable system, or providing Wi-Fi capability to city facilities. The Public Works Authority authorizes cities to operate airports, and of course many cities do, or establish utility services. Cities also have municipal corporate power to discharge their public function and serve their residents, whether it's entering into contracts or leases or other steps that are necessary to conduct city business and operations. And finally, cities have very broad authority under our state constitution to adopt and enforce local ordinances and regulations to promote the public health, safety, and welfare of city residents. This is commonly known as the police power. You'll be hearing a lot about the police power during your time on the City Council. I'm sure many of you served on planning commissions or the like before this, so it may be a familiar concept to you. Okay. The word police itself is derived from the Greek word polis, meaning city. In short, the term police power denotes the power to govern. As stated in our Constitution, and I quote, "A city may make and enforce within its limits all local, police, sanitary, and other ordinances and regulations not in conflict with the general laws." This language, this provision in our Constitution is the power, the source of the power of California cities to protect and promote the public health, safety, convenience, and prosperity of your communities. You have broad and elastic discretion under this provision to adopt local laws to further this goal. You're limited, though, because each ordinance must be related to a legitimate government purpose, which makes sense, and also doesn't conflict with state or federal law, and that's a concept known as preemption. There are countless examples of valid city ordinances or actions adopted under the auspices of the police power. Ones that immediately come to mind include all the land use regulations and zoning laws in your city, fire and safety laws unique to your city, including local building ordinances, and even the charging of fees to cover the cost of providing certain city services. Okay. But there are limits on city powers as well. An ordinance obviously only applies within the limits of the city. It doesn't apply outside the city and the county's jurisdiction in the unincorporated area, even if the person that lives in the unincorporated area uses the mailing or has the mailing address of the city. Cities also can't make gifts of public funds. Even if a private individual is incidentally benefited, overall, the purpose of the expenditure must be a public purpose. There's a ton of case law on this topic. Your city attorney can help you with this, but the courts generally will defer to the city council's judgment on what constitutes a public purpose. And finally, as we talked about a moment ago, a city can't enforce a local ordinance if it's preempted by state or federal law. So what's preemption? Let's talk about it. The basic rule is when a city ordinance conflicts with a federal or state law that's already on the books, it may be preempted by that higher legal authority and not withstand a legal challenge. In other words, a court could find the ordinance is simply unenforceable and invalid under state or federal law because that law already exists at a higher level. Now, courts will very carefully analyze whether a particular city ordinance that's been challenged conflicts with state or federal law such that preemption results and the ordinance must be found to be unenforceable. The key itself is defining that conflict and what that word means. A conflict exists under lots of different scenarios. In particular, when a city ordinance contradicts or is inconsistent with an existing federal or state law, or when it duplicates or repeats an existing federal or state law, or when the local ordinance seeks to regulate in an area or what's called the field of law that's already fully occupied by the federal or state law already on the books, either as expressly stated under that law, that higher law, or as implied because the scope of that higher law is so extensive or pervasive, there's literally no room left, in theory, for a local regulation or ordinance. For those of you from charter cities, though, there's an extra step in the state preemption analysis for an ordinance adopted by a charter city, because under our state constitution, a charter city has clear authority over municipal affairs, even if the legislature has adopted a law on the same subject. Again, part of this home rule doctrine I mentioned at the beginning. So the first question in the preemption analysis for those of you from charter cities is still whether there's a conflict between a charter city ordinance and the existing state statute. But if there is a conflict, the next question is whether the ordinance regulates in an area that's considered to be a municipal affair, or a matter of statewide concern. If it regulates in the municipal area, there's no preemption, and the ordinance will withstand a legal challenge. But if it regulates in an area considered to be a matter of statewide concern, the ordinance may very well be subject to a preemption challenge. So then the question is, what's a municipal affair and what's a matter of statewide concern? Well, the Constitution provides a short list of categories that we know are municipal affairs. Those include regulating the city police force, city subgovernments, conducting city elections, appointing and compensating city officers and employees. Otherwise, leaving that short list aside, it's up to the courts to decide on a case-by-case basis what a municipal affair is and what a matter of statewide concern is, and that law continues to evolve as well. Examples of charter city ordinances that are not preempted by existing state law because they regulate a municipal affair include ordinances covering the qualifications for local elected office, procedures for adopting your ordinances, contracting for municipal services, and local public works project contracting, for example, in the competitive bidding area. The bottom line is that preemption analysis is difficult, it's complicated, and it's certainly an area where you'll be consulting with your city attorney to determine whether an ordinance that you're interested in is a municipal affair or, in fact, is considered to be a statewide concern. Okay, I'm just curious here. Everyone from a general law city, can you raise your hand? General law city? Okay. How many, what about charter city folks? Yeah, so that's interesting. 3/4 of the cities in California, of the 482 cities in California are general law cities. 121 are actually charter cities. It's we have a little more charter city folks than we usually have, which is good. We've got a website pages on the charter city area that reviews the differences between general law cities and charter cities, the process to become a charter city. I would point you to that for more detailed information. The main difference to remember between those of you in general law cities and charter cities is where you derive your corporate powers. If you're a general law city, you're deriving your corporate power directly, and you're bound by all these state statutes and, of course, your own municipal code. If there's a conflict, we know that state law will prevail, right? But if you're a charter city, your corporate power flows directly from your actual charter and the state constitution itself because you have express authority over these municipal affairs. The advantage for charter cities is clear. You therefore have broader authority and sovereignty to regulate locally if your ordinance covers a municipal affair. Last point on charter cities, there are significant procedural requirements if you're interested in becoming a charter city. 2 ways to do it. The city's voters elect a charter commission. The commission then drafts the charter, or the city council itself can draft the charter. Either way, the charter has to be ratified by the voters, and any amendment thereafter must be ratified in the same way to the charter. Again, the website has a lot of information on this area if it's of interest to you and your residents. I'm going to turn now to a basic overview of the ways that cities raise revenue. We know that cities continue to face challenging times with their budgets, pension issues and the like, including with the dissolution of redevelopment agencies now almost 3 years ago. It's really hard to believe. The time has flown by. Luckily, of course, our state economy has been improving, thankfully, although we all know here that revenue issues remain a top priority and concern for every elected official and city staff person in the room. So let's talk about taxation, the first way to raise money. General points in California, it's clear. General law city, charter cities, you've got the power to tax. There's no problem there. The important point is to remember that there are limits on that power. As we've seen through the initiatives that have been passed by our voters that have amended our state constitution, beginning with the passage of Prop 13 back in 1978 and continuing all the way through 2010 with the passage of Prop 26. Now, we all know that Prop 13 limited the collection of property taxes to 1% of the full cash value of real property. The value is based on the property's assessed value or appraised value when the property is purchased, newly constructed, or a change of ownership occurs, adjusted for inflation by up to 2% per year. A 2/3 voter approval requirement was also established under Prop 13 for special taxes, which was later refined and defined further by Prop 62, passed in 1986, and then Prop 218 in 1996, which also requires a simple majority vote approval for a general tax. Then we get Prop 26 in 2010 that broadly defined all taxes, all local taxes, as any levy, charge, or exaction of any kind imposed by local government, unless it's a fee or a charge or a fine that fits into one of the 7 exemptions included under Prop 26. Cities, of course, also have the GAN limit under our Constitution, passed as well in the late 1970s by the voters, which requires an annual appropriation limit on the amount of tax revenue your city may spend each year, first calculated back in 1978 and then adjusted each year for population and cost of living increases. Of course, your city finance director and your city manager are experts on these tax issues and can answer detailed questions about your own city budget, how it's affected by these constitutional requirements and limitations. But with this very basic overview, there are 2 things to remember, that there are 2 types of taxes, general taxes and special taxes. A general tax requires that the proceeds of the revenue raised goes into the city's general fund and can be spent on any municipal purpose in your discretion as a city council. The council's 2/3 vote and a simple majority vote of the electorate voting in your local election is required to pass a local general tax. The other type, again, is the special tax. This is when the proceeds or revenues are restricted for the earmarked or specific purpose of the tax. 2/3 vote of the electorate voting in the election in your city is required to pass that local special tax. Examples of common taxes that cities regularly impose include local sales tax, utility users taxes on utilities, water, telephone, cable television, transient occupancy taxes on hotels, motels, other short-term or lodging stays in your cities, and business license taxes. Again, imposing or raising these taxes requires voter approval, 50% for a general tax, 2/3 majority for a special tax. Another major way that cities raise revenue is the charging of fees. The police power provides broad constitutional authority for you to do this as a city council by your majority vote. That's all it takes. But since the passage of Prop 26, any new fee must be sure to fit in one of those seven allowed exceptions listed in the measure. Otherwise, you run the risk the fee could be considered to be a tax subject to voter approval, and it would be a 2/3 voter approval if it's for a specific purpose. Fees must aim to cover the cost of providing the service, such as, for example, issuing a building permit or connecting to a sewer line. Another type of fee is a development impact fee. Whatever kind of fee it is, it can't exceed the reasonable cost of providing the service or the facility for which the fee is being charged. Otherwise, you run that risk that it could be considered to be, by a court, a special tax subject to 2/3 voter approval. A third way that cities raise money is through the formation of assessment districts. Now, assessments are not taxes. The city can levy an assessment or charge on properties or businesses located within an assessment district to pay for public improvements or public services that specially benefit those properties or businesses subject to the assessment. There are many state statutes that expressly authorize local assessments for various purposes, and a city must follow the procedures in those statutes or under its own charter, if there's a provision in the charter, to form the assessment district and levy that assessment. Examples of common assessments we see across the state are charged for constructing or maintaining public improvements such as streets, lighting, landscaping, and even for services, mosquito abatement and flood control. However, under Prop 218 passed in 1996, only the special benefit provided to the property in the assessment district is assessable, and the assessment amount must be imposed proportionate to the special benefit provided, and it must be approved by the majority of the property owners who will pay the assessment. Now we'll take a quick step back and remember an important point. As a practical matter on these three types of raising revenue, your constituents may generally refer to all of them as taxes. But it's important to remember that taxes, fees, and assessments are not the same things. As you just heard, they're substantively different, and they're enacted in different procedural ways. So you need to work closely with your manager, your attorney, and your finance director, who are always available to assist you with that analysis. The last way that cities can raise revenue that we'll talk about here, anyway, is debt financing. Cities, we know, can't incur debt that exceeds their income and revenue in a given year, but there are exceptions for certain kinds of debt financing. Cities can issue bonds and other debt instruments to finance municipal improvements and services. They must be supported by a revenue source to pay back the debt, such as a tax or a fee or an assessment. And other exceptions to this kind of, to the debt limitation include certain kinds of financial activities such as lease transactions or installment sale transactions. Again, last point, and I'll say it for the 10th time, you're going to be working closely with your city staff on these issues. They're complicated, but they're ready and well prepared to help you as you consider your city budget and the means that you need to take, or the steps you may need to take to make sure that you have the budget in hand. At this point, I'm going to turn over the microphone to Jane, as she'll be starting to talk about the open government issues and the rest of our presentation. Thank you.
Okay, let me just get this clicker right. Well, thank you, Corinne. She always introduces me. We've been doing this for a number of years, probably about seven years, maybe, 4. Well, I've been doing it for a little while. And I always appreciate working with Corinne. And I, too, would also like to congratulate all of you on your election to the City Council. And I'm sure that most, if not all of you, have some extensive experience working in local government, either in other appointed or elected positions or as an interested citizen and constituent in your communities. So a lot of this will not be foreign to you, but it may be a refresher course, and you may have some different perspectives on open government and transparency now that you are in your roles as city council members and mayors. Transparency in government has become of increasing importance over the years, as I'm sure you know, that there has been, in the past, some unfortunate incidents in some jurisdictions where transparency was lacking, and it has been characterized as scandals, and some public officials have paid the consequence of that. I'm very pleased that we have not seen anything like that in the last few years, and I think that that has gotten the attention of jurisdictions across the state, and also has increased public awareness about open meeting and transparency issues. So what I will be doing is providing you with a general overview of some of the laws, our transparency laws, the Brown Act, Public Records Act, ethics, conflict of interest issues. But on Friday, as Corinne mentioned, you will be having an in-depth session for your AB 1234 training, ethics training, where you will be going into more detail and getting some resources on these subjects. So we're going to first start with the Brown Act. The idea behind the Brown Act is that meetings of a legislative body be open and public. The author of the Brown Act was Ralph M. Brown, not the Jerry Brown that we know and love. It was Ralph Brown, who was an assemblyman in Modesto in 1953. He came to the conclusion that there needed to be a change in law. There needed to be laws enacted to provide the public with notice of public meetings. And as a matter of fact, he was very offended during the processes when he was participating in government, and he would attend meetings, and then he would leave the meeting, and the decisions that were made at the meeting were then changed by closed-door or backroom deals that were made following the meeting. So he worked with the League of California Cities at that time and the California Newspaper Association to craft an open meeting law, the Brown Act, which at that time was all of 2.5 pages in the government code. The Brown Act is now over 50 pages in the government code and other places where you have to kind of look around and just try to find the appropriate law and statute. So it has become very complex over the years. And it sounds very simple. It requires meetings to be, of a legislative body to be open and public. And every word of that simple definition has become analyzed, parsed, interpreted, court laws, attorney general opinions, city attorney opinions to interpret what that all means. And so we'll go through some of those words with during this presentation. So we'll first start with what is a legislative body. Of course, your participation on the city council, you are a member of the governing body of the city. But there are also other bodies that are legislative bodies under the Brown Act. Newly elected members who have not yet assumed office, but I assume that all of you have probably been sworn in by now. But during the period of time during the election before you're sworn in, you can still be considered part of the legislative body. So in terms of what constitutes a meeting or a quorum or a serial meeting, which we'll be talking about, newly elected officials who have not been sworn in are technically members, still members of the legislative body. Appointed bodies are legislative bodies, and those are your boards and commissions, such as the Planning Commission, your Civil Service Commissions, and as you may know, and many of you may have been members of those boards and commissions, those meetings must be compliant with the Brown Act and noticed and open to the public. Standing committees of the council are also legislative bodies in and of themselves. So if you have a committee that is appointed for a particular purpose, say a finance committee of your council or a budget committee, even though it is composed of perhaps less than a quorum of the council members, those committee meetings committees are considered legislative bodies, and the meetings must be noticed and must comply with the provisions of the Brown Act. Also, and this is something that gets overlooked sometimes, is that private organizations can sometimes be considered a legislative body. And that is when the city provides funding to a private organization, and as part of that funding, a member of the council is a member of the board of that organization as a condition of that funding. So if, let's say, I'll use for an example, a chamber of commerce or a business organization within your community receives city funding, and a member of the city council is a member of the board of that private organization, those meetings of the private organization must be noticed and open to the public. Can I go backwards?
I never thought I'd say I'd missed the clicker, but I definitely missed the clicker.
Okay, here we go. Okay, there are some things that are not legislative bodies, and one of them is a temporary advisory committee composed of less than a quorum, and this is commonly referred to as ad hoc committees. So first thing you need to know is what is a quorum of your body. So let's say you have a 5-member council, a quorum is 3 members. But if you have a committee of 2 of those members, that is less than a quorum. And if the committee is of a temporary nature, that is, it's going to perform a particular function or look at a particular issue, and then it's going to go away, that is a ad hoc committee, and it does not need to comply with the notice provisions of the Brown Act. Of course, you can also open your meetings. I mean, that's always, you can always do more than what the Brown Act requires. And some cities have sunshine ordinances that require enhanced notice and participation. But if you have a less than a quorum or an ad hoc committee of your council that is temporary in nature, you do not need to provide the notice and public process that's required under the Brown Act. Also, groups that advise a single decision maker. These can be staff that can talk with you and be your kind of kitchen cabinet, or some constituents that you organize to advise you on certain issues. Those meetings do not need to comply with the Brown Act. You must be careful, however, particularly when you're interacting with staff, that the staff member is not acting as a conduit to talk with the various council members about a particular issue, and we'll talk about serial meetings and developing a collective concurrence about an issue. But it does not prevent staff briefings with you individually so that you can get up to speed on particular issues. We're next going to talk about meetings. And I'm going to do all of the words on here. Okay. So, again, definitions are very important, and each word means something. So a meeting is defined as any gathering of a majority of the legislative body to hear, discuss, deliberate, or take action on a matter within the agency's subject matter jurisdiction. So, as I indicated, all of these words have been interpreted by the courts. So we need to know, we've talked about what a legislative body is. We also need to understand what hear, discuss, and deliberate means. You do not need to take a vote on something. It does not need to be a gathering where you are taking an action. It can be a meeting when you are just listening, or if it is a gathering or a meeting where someone is trying to develop a collective concurrence amongst the group council members on a particular subject. So it's very key that some people may think that in order for there to be a meeting, there has to be action taken. But a briefing or just the presence of a majority of the city council to hear issues that are within the subject matter jurisdiction of your city constitutes a meeting. Again, oral collective briefings, as I indicated, if the staff is providing you a briefing on an issue, that is a meeting. Legislative retreats. It at one time was thought that a retreat was something that would be a team-building gathering amongst the members of the City Council, and that the public did not have a right to participate in that process. Well, that is not the case. Legislative retreats are meetings, and those retreats must take place within the boundaries of the city, and they must be open to the public. And serial meetings, as I mentioned, that is when you're not necessarily in the same room at the same time, but your conversations can become a meeting. And I'll click onto the next slide to talk more about that. The basic concept of a serial meeting is you can't do anything outside of a meeting what you should do in a meeting. So sometimes it's called daisy chain or hub and spoke meetings. And that's where one person may talk, one council member talks to another council member, who talks to the third council member, and when you have 3 members who are a quorum and they make a decision, even though they're not in the same room at the same time, that is a serial meeting, and that is a violation of the Brown Act. Click on a couple more of these. Now, that has become very interesting in this day and age of social media and electronic communications. It's very easy to send an email, a text or a tweet to a colleague to ask his or her opinion on a particular issue. That person responds or presses the reply all button, which I recommend you kind of tape up on your computer. And before you know it, a majority of the council has weighed in on a particular issue via email. And you may not have voted on what that issue is, but by virtue of your email discussion, you have developed what is called a collective concurrence. You've agreed, you've had a thought process outside of the public's eye and outside of a public meeting to reach a decision or a conclusion on a particular issue. As I indicated, individual staff briefings are okay, but that staff member cannot be the conduit to say, well, council member A's opinion of this is this. What do you think? Well, now we have 3 votes, and that indicates a serial meeting. And written communications to the council are also okay if those written communications, again, aren't for the purpose of developing a consensus or collective concurrence on an issue. So a staff report, of course, can go to the council members and advise them on a particular matter. So what are not meetings? And as I indicated, individual contacts are not meetings. Your constituents can contact you. There may be lobbyists who contact you about a particular issue that they are advocating for, and that's okay, and that's part of your responsibility as a public official and representing the interest of your constituents. You can attend conferences such as this, but you cannot discuss amongst yourself, if the quorum of the council is at this particular conference, you cannot discuss items that are within the subject matter jurisdiction of your body unless it's part of the program. So it's good if the majority of the council is going to a particular conference, it's good to sit at different tables if possible. You can attend community meetings. Again, you need to be cautious about weighing in and making decisions at these meetings. I have one situation where a majority of the council attended a community meeting, and the conveners of that meeting had a letter that they asked all of the council members to sign supporting their position, which they did, and that ended up to be inappropriate because they were then weighing in the majority of the council on a decision that should have been made at a notice and public meeting. You can attend meetings of other legislative bodies, and that frequently occurs if you're attending meetings of other special districts or even going to Sacramento and meeting with state legislators. Social and ceremonial gatherings are appropriate. You may have had swearing-in ceremonies, and as long as you did not conduct city business other than the ceremonial swearing-in and reception, that was appropriate if it was not noticed as a public meeting. And you can attend standing committee meetings as an observer. You can sit in the audience and listen to the proceedings at a standing committee, but you cannot participate. You can hear and observe, but you cannot participate because then that would constitute a meeting. One practice point that I've advised is if you think that there is going to be interest amongst the majority of the City Council in a particular issue that's before your committee, you should notice it as a special meeting of the Council. Or you can notice it as a joint meeting standing of the committee and the City Council. And then that way it's kind of belt and suspenders, and you have the notice requirements in the event that somebody on the council wants to participate in the standing committee's meeting. So the public needs to know when you are meeting, and that's when the notice and agenda requirements kick in. So your regular meetings require a 72-hour notice requirement, and some jurisdictions have requirements that even require a longer notice, and that's quite all right. Special meetings require a 24-hour notice, and also the notice must be posted on the city's website. And the items to be discussed, the agenda, must have what is characterized as brief general descriptions of the item to be discussed. It doesn't necessarily have to state what actions or potential actions the council will take on a particular item, but it has to give enough notice to the public that they have a general understanding of what subject is going to be discussed and whether or not they want to come to the meeting or not and weigh in on it. So there has been kind of a rule of thumb of about 60 words as a general description, but it has to be enough to give the public an idea of what the subject matter of the item is. Teleconferencing. The Brown Act allows for teleconferencing as long as it's not a majority of the council who are teleconferencing in. A majority of the council must be at the location, the meeting location. But if a member is going to be away, they can teleconference in, and there's some specific rules on how that is done. Number one, it must be posted in the agenda that that particular member is going to be teleconferencing. It must give the location of where that member will be. And the member must post at that location the agenda and give the public an opportunity to participate at the meeting, if it's at the hotel, in a hotel room or in a conference room, and there must be a speakerphone so that they can hear the proceedings. An interesting question came to me as to whether or not a member could participate by teleconference in a car while they were traveling. And I said, well, gee, you know, that you're not able to post the agenda or give the public an idea of where you are, unless you are going to be stopping at a particular rest stop or whatever, and that's going to be your location. So I don't think that that's such a good idea to be in your car, on the phone, teleconferencing in on a meeting. So you cannot discuss non-agenda items unless under very narrow circumstances. And those exceptions are if it's an emergency or if it's an urgency. Emergencies and urgencies kind of get mumbled up and confused sometimes. Not everything is an emergency. An emergency is when prompt action is necessary due to disruption of threatened disruption of public facilities, a work stoppage, or other activity impairing public health, safety, welfare, or a crippling disaster. So an emergency is a real emergency. And in order to take action without the publication of an agenda notice, the body must vote by a majority vote and make the findings that this is actually an emergency, an earthquake, horrendous fire, some flood, some other catastrophe. An urgency is a need to take immediate action that came to the attention to the body after the posting of an agenda, and that action cannot wait until the next meeting. So the fact that staff forgot to put it on the agenda, or somebody is going to be going on vacation and won't be there at the next meeting, that doesn't necessarily constitute urgency. And in order to take a matter up off the agenda as an urgency matter, the body must vote by a 2/3 vote that it is in fact urgent. So for example, if it comes to the city manager's attention that they have an opportunity, the city has an opportunity for a significant grant, but the application is due the next day, and it just came to his attention and it cannot wait until the next meeting, that would constitute an urgent action. Public comment. Public comment is a portion of your agenda that allows the public to talk about anything within the subject matter jurisdiction of the city. And that is very broad because just about everything falls within the subject matter jurisdiction of the city. So you have to give the public an opportunity to make public comment. The council cannot discuss or take action on any of the comments, but they can make brief general referrals or brief statements in response to public comment. For example, can refer the matter to the city manager to look into, schedule it for another meeting, ask maybe a brief follow-up question, but you cannot engage in a discussion regarding the matter. You can impose reasonable time limits on public comment. The fact that you have a lot of members from the public lined up and your meeting may go longer than you anticipated is not a basis for cutting off public discussion. But you can have rules and procedures in place to have time limits for public discussion. Another good practice point is to, if you have a large contingent of public speakers and you know that they're going to be there, you may want to try to facilitate the discussions and ask if a designated speaker might want to have more time to talk on behalf of the group, or to have an agreement that you will reduce their time and they will not be repetitive in what they are talking about. But the bottom line is patience is a virtue with public comment sometimes. Okay. Okay, this is, why is it doing that? There we go. Okay, closed sessions. Closed sessions are specifically provided in the Brown Act when it allows you to go behind closed doors and talk about confidential matters. And some of those examples are in litigation, real estate negotiations, public employment, labor negotiations, and you must have a closed session notice describing what those issues are that you will be discussing in closed session, and you cannot go beyond those discussions in the closed session. You have to stick with the noticed agenda item. In the Brown Act, there are what there's called safe harbors for descriptions, and your city clerk and the city attorney can assist with that. And that provides a degree of immunity in terms of whether or not you have noticed a closed session properly. After you've had a closed session, there are requirements that you must report out final actions that have been taken in a closed session. In litigation, for example, it is not final, a decision is not final until a lawsuit or a settlement is accepted by the other side. So the fact that you may give authority to your city attorney to settle a matter for a specific amount, you do not need to report that out because the city attorney then has to have an opportunity to go back to the other side, get the approval, get the settlement agreement signed, and finalized. So that is not a final action. In closed session, only the persons who are involved in a particular matter are entitled to be in the closed session. So if a staff member is not involved in a particular litigation matter or a real estate negotiation matter or personnel matter, those persons should be excluded from your closed session. Confidentiality of closed session is very important, it's very critical. If the maintenance of confidentiality cannot be maintained, it can result in serious consequences for your city, not only in terms of bad results in your labor negotiations or litigation, it can result in serious financial consequences for your city. There are remedies or penalties for council members of the public agency who violate the confidentiality rules. And the Brown Act specifically states that the city can institute injunctive relief to prohibit the member from participating in the closed session. It can refer the member to the grand jury, which could result in a potential criminal indictment, or the council can have procedures to censor that particular member for repetitively violating the confidences of closed session. So you should be very careful about not disclosing confidential information. Brown Act also requires or states that you can, however, if there is a violation of a closed session discussion, you do have a right to refer that to the grand jury and disclose the information if you feel that there has been a violation of closed session, where something that should have been discussed publicly was discussed in closed session. The Public Records Act is another one of our transparency laws, and there's always a question of what is a public record. Assume that anything that is produced as part of the public's, your public process is most likely a public record. There are a number of exemptions that your city attorney can determine whether or not it should be disclosed or not. But basically, it's a broad definition that public records, public documents that are produced in the course of business are public records. Again, we're being challenged about electronic data. and electronic emails and electronic communications are, in fact, public records. There is a case that is percolating up to the California Supreme Court out of San Jose, which deals with personal information on your personal phones, smart pads, or computers, and whether or not that information, even if it involves city business, is a public record. Cases at this point has held that information that is on your personal device is not disclosable as a public record, but we'll see what the Supreme Court says about that. A lot of jurisdictions, a lot of cities give iPads and smartphones to the members, and if you are using a city-issued device, the communications could be subject to disclosure under the Public Records Act. Another new case that came down was a disclosure, inadvertent disclosure of a confidential attorney-client communication that was disclosed by mistake, and the city tried to get it back because it was confidential and was not to be disclosed. And the court held that the inadvertent disclosure made that document a public record. And so you have to be very careful to screen what you are giving out, and you have a window of opportunity to review documents for release under the Public Records Act. Again, consult with your city clerk or your city attorney regarding public records. There are some exemptions, as I indicated, and one of them is a balancing test where it allows the non-disclosure where the public interest in non-disclosure clearly outweighs the public interest in disclosure. So in that respect, when you're looking at confidential documents, health records, Social Security numbers, threats of public security, we look at the balancing test, and those documents do not necessarily need to be released. The League has an excellent publication that they have just recently revised and updated that I would call to your attention. Okay. There we go. So ethics, as I said, you're going to be getting a lot more information on ethics and conflict of interest, but the Political Reform Act, which is overseen by the Fair Political Practices Commission here in Sacramento, basically prohibits a city official from making, participating in, or influencing a government decision in which he or she has a financial interest. It also covers that you should not take perks or receive personal advantages above and beyond which you are entitled to receive in your positions. You have reporting obligations to the FPPC. You must file your Form 700s and other appropriate forms. And there are gift limits. The gift limit increases each year. This year it's $460 a calendar year that you can receive gifts from a particular individual without being precluded from taking any action with respect to that individual. And I think you may know that if you receive a gift valued at $50 or more, you must report that on your Form 700. Government Code 1090 is the very strict requirement that prohibits officials from having a financial interest in the agency's contract. So it is the self-dealing statute. You cannot advantage yourself as a public official by taking action on a contract that you have a personal financial interest in. That is, I say, the go to jail statute, and there have been. So you want to stay away from that. And one of the overarching rules that is not codified is what I call the smell test. And if it seems a little out of sort, if you have a question regarding a contract that you may be involved in, and if you have to think twice about it, consult with your city attorney and use caution, because you do not want to get into a position of taking an action that would be in violation of Government Code 1090. The consequences of that, in addition to the fines and the penalties, including imprisonment, is a lifetime disqualification from public office, and the contract that is under discussion becomes void. So you do not want to get involved in a Government Code 1090 issue. The other ethics issue that sometimes arises is the incompatible offices prohibition. And believe it or not, you know, some public officials want to hold more than one office. If those offices are incompatible, you are precluded from doing that. You are precluded from being an employee of the jurisdiction or the city that you are a city council member of. If you are elected to the city council and you were a city employee, you must resign your position, your city position. So you have to look very carefully as to whether or not the board or commission that you may be on conflicts with your role as a city council member. An easy example would be you can't be a member of the school board and also be a member of the city council, because the city council does take issues that relate to the school district, and there could be a conflict of allegiance to each of those bodies. So, very quickly, because I'm running out of time. I should get more time cream for having to click this. There it is. Okay. The council member's role with respect to city employees. You have no role with respect to city employees except for those employees that you appoint. And generally those are very narrow: the city manager, your city attorney, and sometimes your city clerk. Otherwise, the business of the operations, the personnel operation of the city must be handled by the city's city manager or the highest ranking employee, the supervisors or the department heads. Some cities that have city charters have specific rules with respect to non-interference with the administrative affairs of the city, and so it's your role to be the policymakers and not the administrators of the city. With respect to the city council and the city attorney relationship, the city is the client. The city is a municipal corporation. The city is the client of the city attorney, not the individual council members. So there is no attorney-client relationship with respect to the city attorney and individual members, but there is a relationship, and there is a relationship of trust and confidence where you should feel comfortable in communicating issues and discussing issues with your city attorney. But the city attorney cannot guarantee that those conversations or those opinions that they're giving you are going to remain confidential between you and that council member, because the confidentiality and the attorney-client relationship rests with the city as a whole. So frequently the city attorney will say, well, I'm going to inform, this is my opinion relative to this issue, and I'm going to inform the rest of the council what I've advised you. So I think that's very important also with respect to issues that involve conflict of interest or other issues that may jeopardize actions that the council as a body may take. very important that you relay all of the pertinent facts to your city attorney so that they can make the proper decision, and recognize that there is not always a concrete answer, and gray is a very, very predominant color in city attorney world, because there are various sides to analyzing a position, and so you should realize that you're not always going to get a precise answer, particularly when that question is being raised at a council meeting and the city attorney is on the dais. They may say, I'll have to look into that and get back to you with the answer. So we're going to entertain some questions, and although Corinne and I cannot give you legal advice, we will attempt to answer your questions and clarify any questions that you've had. And so thank you very much for your attention.